The challenges to Obamacare are not over. Once again, it's in federal court, this time over an alleged power grab by the IRS. Some small business owners arguing the agency is forcing them to pay huge fines if they cannot cover their employees. Shannon Bream is live in Washington with more on that controversy. Shannon.
Well, John, the plaintiffs in this case, which is here in federal court in Washington today, say the IRS is doing an end run around Congress using a federal regulation to go far beyond the plain text of the Affordable Care Act. They say, as it is drafted, the law only provides subsidies to people in states where the states themselves have set up exchanges, but not into states where the federal government is operating the exchange. This is a very important distinction because once a subsidy is activated in any particular state, that also then triggers employer obligations, including those penalties of up to $2,000 per employee for not providing insurance. These plaintiffs argue that by extending subsidies to all of the states, even those without state exchanges, the IRS is both violating the law and creating massive burdens for employers.
Basically, it's not as if the IRS, by the way, is acting as a rogue agency here. I think what they're doing is, deliberately by design in concert with the administration's intention, it's going to be a huge undermining of the very notion of the rule of law.
The government, in its motion to dismiss this case, argued, quote, the plaintiff's reading of the act is wrong. Congress made clear that an exchange established by the federal government stands in the shoes of the exchange that a state chooses not to establish. And the Treasury Department has reasonably interpreted the act to provide for eligibility for the premium tax credits for individuals in every state, regardless of which entity operates the exchange. Well, by the way, the government's motion to get this case dismissed was denied. Today, both sides are set to make their case around 2 o'clock Eastern Time. John?
Shannon Bream in Washington. Let us know what happens. Thanks.
It is such an interesting case. We're going to talk a little bit more about this with our legal panel. Doug Burns is a criminal defense attorney, and Fred Tisi is a former federal prosecutor. So Shannon laid that out really great for us, easy to understand. It's just a very complicated case. Bottom line, Fred, is the question whether or not if basically you are in a state that has not set up its own exchange, if the federal government works instead of that, and you can still get your subsidy. It's a big question in the wording. Those enrolled through an exchange established by the state get the subsidies. That's what the word says. Do they have a case?
Do they have a case? I'm going to tell you something. Before Dr. Crownheimer said this lawlessness began, this case would be a slam dunk. It's very simple. When you talk about interpreting a statute, Jenna, the words of the statute control, and the words of the statute define as exchange as set up by a state, and they authorize subsidies for exchanges as defined in the statute. And this is the irony of this. The law presumes that Congress knew what they were doing when they passed the statute. That's the end of the conversation.
But as Shannon pointed out, Doug, what the government is saying is we all know what the law meant. It meant to say that if the state didn't set up the exchange, then the federal government's exchange fits in the shoes of where that state exchange was supposed to be.
First of all, the law itself says that the federal government can set up exchanges in instances where the states don't. Second, there's a section that provides that both state and federal exchanges must provide or report data about the credits or subsidies. So the legal argument is really quite simple on the other side of it, which is that if you look at the statute as a whole and you look behind what appears to be a drafting mistake as against the other sections, then it's not quite as clear as my learned colleague Fred Tisi makes it.
Well, that's the question, Fred. And the Washington Post actually laid this out really simply. We have to remember that when the law was drafted, there were no exchanges. So the law was drafted and the exchanges were supposed to be set up. So the Washington Post says, listen, either there maybe was a missed word or it was intentional because the federal government wanted the states to set up their own exchanges, and the subsidies was the carrot that they were dangling for the states to set it up. And therefore, it was intentional.
Right. Well, look, first of all, Doug's doing a good job. I mean, he's making the best argument that you can make if you're on his side. But this cuts everything that you just said, Jenna, cuts against the IRS's position. They set up exchanges. The law specifically identified state and federal exchanges. But when they wrote the section of the law that indicated who was going to get the subsidies, they specifically did not include the federal exchanges. And at the end of the day, even if it was a mistake, a typo, as my learned colleague tries to say. It's too bad because mistakes are drawn against the drafters under our law system, which has worked for 30 years up until the last 8 months.
So what would it mean, Doug? Let's say this argument goes through. Then what does it mean if you're in a state that did not set up their own exchange as you're working through the federal government website? What's the effect, potential effect?
It's very simple, Jenna. Either the judge is going to say, as Fred suggests, that if you look at this section, 1321, it only applies to exchanges set up by a state, or the judge is going to rule, look, the intent of the law. And by the way, this goes to the core of legal methodology, which is, the whole the whole concept of, plain meaning of the words, strict textualism versus looking at legislative intent or the intent of the drafters. This judge may look at what the legislative discussions were when the law was formulated, and then guess what? We're going to solve this big mystery as to whether it was a mistake or it was intentional.
But the law has always been, Doug, if that's what they meant, then that's what they should have said, and that's not what they said.
So, Fred, then if that was the case, then would it go back to Congress, Fred, to fix the wording?
Yes.
And would Congress have to agree on the wording to get the? I mean, I know Congress agree, right? Maybe that's the joke.
Yeah, right, that's what I'm laughing about.
But would that have to happen then for those states to get subsidies?
Yes, that's what would have to happen. And this is what happens when you ram a bill through with no back and forth, no bipartisan support. Ultimately, because of the mistakes that were made, the irony is, as you just noted, Dana, that the legitimate, the lawful fix for this would be to send the law back to Congress and tell them to fix it.
But then
Go ahead, Doug.
Yeah, no, then you get into the separate seminar, about, legislating from the bench. Critics would say that is legislating from the bench, but those on the other side would say, no, it isn't. It's just interpreting the statute.
Okay, so this is a very interesting seminar. I'm not sure if I'm ready for the next one. Before I let you guys go, really quick, what do you think is going to happen here? Because we've seen all these challenges to the health care law. This is an interesting one. Just real quickly, Fred, and then you, Doug. Okay. What do you think is the end result here, and what's the impact?
You know what, Doug and I have about 60 years of experience between the two of us, and both of us looked at this and said should be a kind of a no-brainer. I want to talk for him. But the whole legal system is upside down where the Affordable Care Act is concerned, and quite frankly, the lawlessness has to stop. What should happen is it should be upheld as written, and the IRS has overstepped their bounds.
Doug?
Well, I'll leave you with a sad commentary, which is that if this were a case not involving a hot-button issue, not involving something that everybody's looking at as closely, then perhaps I think it would come out the way Fred's suggesting. Since it is such a hot potato, I'm not so sure, and I think the courts may support it. We'll see.
It'll be very interesting.
And that's the problem.
The subsidies are a big part, a really big part of this law for so many reasons, including, of course, obligating employers to do certain things. So, Doug, Fred, look forward to having you back. Thank you so much.
My pleasure.
Thanks for having me, guys.